It is June 12th of 2026, and this is the Court Gallery. What starts as a simple traffic stop for a trucker quickly becomes a lesson in court procedure. A woman's love for her dogs lands her in a world of legal trouble after she makes a purely emotional decision. A judge has absolutely no time for a property owner's excuses, telling him to his face not to blow smoke up his beep. And a plumbing job gone wrong turns into a classic small claim showdown where a single piece of paper, or lack thereof, decides everything. Stick around. You won't believe how these cases turn out. And it all starts right now.
Mr. Muhammad, go ahead and unmute. Good morning, Mr. Muhammad.
Good morning.
Are you going forward today without benefit of a court-appointed attorney?
No, that's just, I'll go ahead.
Want to talk to an attorney?
Yeah, I'll go ahead and just pay the fine because it's getting tedious, to be honest with you.
All right, so yes, you want to go forward without speaking to a court-appointed attorney?
Yes.
Okay, so the deal the prosecutor put on paper was that you were going to plead guilty to this misdemeanor charge of interfering with police officer on November 17, 2025. The prosecutor is recommending a delayed sentence for 6 months. Is that what you've agreed to?
Yes. Is that within that 6 months to time if I get no infractions, anything that'll be dismissed or something like that?
Yeah, basically, as long as you do whatever I tell you to do, which the main one is to stay out of trouble, then at the end of 6 months, this will be dismissed. It will not stay on your record as a permanent conviction. That's okay. What the delayed sentence means.
Yes.
All right. And do you understand your rights and the options those rights present to you?
I do.
Do you understand the possible penalty for this charge?
Yes.
And understanding all of that, are you pleading guilty freely and voluntarily to the charge?
Yes.
All right. So what happened on that date of November 17, 25 in Romulus that makes you think you're guilty of interfering with a police officer? Did you give him bad information about your name, or did you refuse a lawful command? What was going on that makes you think you're guilty of the charge?
Like I stated before, it's just kind of this because I'm a truck driver, and it's like
Can't see that. Okay, hold on a minute. Your audio
to be honest
is
with you,
really bad. Your audio is really cutting in and out.
How about now? Can you hear me?
That's more clear. So give me the facts that support this kind of plea.
Okay. Yeah.
What happened on that date?
I pulled up to a service station after leaving a drop. And the service station used to be where truckers could park at, but apparently I was a week late after they put the notice, so no truckers was supposed to park there. I really wasn't parking there. I just threw my flashers on just to go run inside to grab me some coffee. And then when I pulled off, he pulled me over, and I think he kind of power tripped out on me while asking for my, I was asking him what did I do wrong. At the same time, while kind of fumbling through my wallet for my ID, and I think he asked me more than one time, and I think he kind of power tripped out, and then he snatched me out of the vehicle and towed my truck and all this unnecessary stuff for.
Okay, so there was a delay. There was a delay between when he asked you for your ID and paperwork and when he provided it. Is that what you're saying?
He was in the passenger. He was hanging in the passenger seat window, and he asked me for my ID. And I immediately, when he asked me for my ID, I asked him, what did I do wrong? And then he repeated, I need your ID. So as I started looking for the ID, I may have paused for a second and asked him, could he tell me what I did wrong? and I think he got a little aggravated that he had to
Okay.
ask me, or maybe I wasn't finding it fast enough for him, and then he ran on the passenger side, said he was going to shoot me in my face if I drive off, and all this unnecessary stuff. You know what I'm saying? But
All
going to
right.
get a cup of coffee. Be honest with you.
The facts you've told me support a plea for interfering with a police officer, so I'll take your plea, accept your plea, and on this file, a delay sentence for 6 months. Court costs are assessed the amount of $200. We've also got a civil infraction, looks like from the same day. Looks like you made some payments and then stopped. We've got a balance of 140 on that one. So
I'll pay that
all
today.
totaled, you owe this court 340. When can you pay that 340?
Today.
You gonna do it online? You're gonna stop in so my cashier can give you a smile?
I'll probably do it online.
All right, I'll give you until tomorrow just in case you have some problems.
Okay, and I appreciate the smile.
Well, you probably won't get a smile online. Here, I'll give you one right now.
There you go.
That's it. That's it. Any questions?
No.
Enjoy your day. All right, Ms. Miller, come on up. Your appearance, Mr. Bowditch.
On behalf of and with Ms. Miller, Your Honor, today's date and time set for Raymond in the Senate. We will really stand you. We also had a chance to pre-try this. Ms. Miller is also accompanied by her 15-year-old daughter, Malaysia. Spelled Malaija.
Is this Ebony Miller Judge or Lisa Miller or who's my Miller?
No, it is.
Ebony?
Yeah.
Yeah. Oh, Lisa?
This is a violation of parental responsibility. Your Honor.
Yes, Ebony.
Ebony.
Yep.
Okay. And how old are you? 15? All right, go ahead, Ms. Bowditch.
Your Honor, Ms. Miller is pleading guilty to the charge of violation of parental responsibility. I don't believe I have an accurate count of the days, but I believe it'd be more than 20. Is that true?
You agree, Mom? More than 20?
Yes, it was, far as like her being there, but
Hold on, don't get there yet. Don't get there, just days. More than 20?
yes.
Okay, I can accept your plea.
So this Miller's going to plead to the violation of parental responsibility. The matter will be taken under 771 for a period of 12 months. If she complies with all the court's wishes, in essence, Malaysia's attendance, the matter will be dismissed. I had a lengthy conversation with Lisa and Malaysia. I think more, I had a conversation with Malaysia about why her mother is in court. I believe the problem has been addressed
Okay,
and is waiting to be accomplished.
okay. Did you go over your rights with Mr. Bowditch? You understand your rights and options?
Yes,
You understand the possible penalty for this charge?
Yeah.
Understanding all of that, are you pleading guilty freely and voluntarily? All right, based on what you've already told me, I can accept your plea. All right, so why weren't you going to school?
Cause we had both, but we ready to get on the bus to drop me off, but she doesn't want to get on it.
So she'd take you home at night.
She take me home after school.
That's what I mean. Yeah, after school, you got on the bus, she dropped you off at your house. Okay, all right. All right, so I've got an address on Beverly Road. Is that the new address or the old one? Where's the new one?
next, and I resolved it with Kathy.
Kathy at Transportation?
Yeah, Kathy, yes.
All right, go ahead, give me the new address.
There is the 6005 Dexter Street.
We have it. This is Judge.
We got it? Okay, okay. All right, so we got that resolved for next year?
Yes.
Okay. What's your GPA? Are you, first of all, what were you this year? Were you a sophomore this year or freshman? What are you next year? Did you earn enough credits to be a sophomore or are they just moving you through? You got to catch up. So you got to catch. She did?
Yeah.
Okay. All right. So what's your GPA?
She don't know, I know, she.
Well, hold on. Don't tell me. Don't tell me. Let me tell you, I've been doing this a long time. And anytime I've got a high school kid that tells me they don't know what the grade point average is, you know what that means to me? it's not as high as it should be. Is that true? No? You got the best grade point average you could possibly have. Then that means it should be higher, right? Why isn't it as high as it should be?
So I got one class. That's like yearly.
Yeah, but why is your grade point average not as high as it could be? You're not working as hard as you could be working, am I right? All right, so what do you want to do when you're old? You're 25 years old. What do you want to be doing? What do you dream about doing? You want to build houses. That is the first time in almost 30 years I've ever had a young lady tell me she wants to build houses. Good for you. Why?
That's why I be seeing them about all these stuff.
Okay, it looks interesting. So you need to get a job working with your hands. Okay, all right. So do you think you can be too smart academically to build houses? You're afraid of putting too much information in your head to make you a bad house builder? Here's my point. I would be surprised. I hope whatever, if that's what you dream, I hope it comes true. But I would be surprised that when you're 40, you're doing what you say you want to do now. Because most people, when they're 15, really don't even have a clue about what all the options are, and they end up changing their career path. Would you agree with me that that's probably true about a lot of people? Okay. So here's what I like to tell people your age. If you understand that your career path may change, you might go 10 years down one path and decide you want to go on another one. If you agree that your career path may not be exactly what you think it's going to be at 15, don't you think for your own benefit, you should have the most solid foundation you can have so that when you decide on another career path, you've got all the ducks in a row that it takes to go on that path? You know what it takes to build that foundation? The best education you can get in high school. Because regardless of where you come out in high school, your grade point average to a great extent determines what options are available to you. Okay? So if you come out of, you're going to go to Romulus for high school? Plan on finishing there? All right. So if you come out of RHS and you got a 4.2 grade point average, you got a whole bunch of options that are not available to you if you come out with a 1.5. You agree with that? So shouldn't you be working your butt off now to make sure that your grade point average is as high as it could possibly be when you're done with Romulus High School? Are you going to be doing that next year? All right. Any questions, Mom? All right. So you don't go out and rob any banks. No criminal matters in the next 12 months. Her attendance doesn't have a problem next year, and then we dismiss this. All right. Questions? Have a good day, ladies. You're welcome.
We're good.
Okay, so back on the record with Dawn Snyder. Come on, Miss Snyder. I've got 3 files, A, B, and C, ending in 699. Incident date, April 28 this year. I've got 3 files, A, B, and C, ending in 562 with a March 18, 26 date. It sounds like on May 11th that nothing happened, quote unquote, on the record because there's no notes in the files about anything we did. And Heather can't find anything on the, did you check your recording or just Zoom?
I checked Zoom and I just listened to the recording.
Right. So whatever thought was done on the 11th of May didn't officially get done. So where we're at today is 6 files. Mr. Greco, Mr. Bowditch, what are we doing, Will?
Mr. Greco had offered that, I believe he said it was 7 files.
Oh, maybe I missed one. Well, you got one still there? No, I got 4 files ending in 62. Yep. Okay, go ahead.
The deal that was offered, I haven't talked with this young lady about it, but Mr. Greco had made an offer to plead some and dismiss the others. I think plead 4 and dismiss 3, all dog or law.
And get down to 3 dogs. Because a lot is 3 dogs.
That was a yes? I'm sorry.
Yes.
Okay, put your name on the record. Thank you. You understand the offer? Okay. You understand your rights and options after discussing those with Mr. Bowditch? Okay.
Yes, we-
Not yet. Let me get my questions out. You understand the possible penalty and you understand your rights and options, correct? Okay. Is that what you want to do, is to plead to, was it 3 and dismiss 4?
Plead to 4, dismiss 3. It would be like 2 dog at larges, the 1 animals, that's the having more than 3, and the 1 no license. So the one that she brought back, that she's definitely ordered to surrender, and her probation was dismissed in default.
Not these files, other files.
Right, no, but the no license is for the dog that was back.
Right,
License, because she wasn't supposed to have it.
right.
So one file is animals, that's the too many animals.
Yep,
One file is no license,
yep.
and then 2 dog at large.
Those are the 4 I've got from May 18th. Okay, so your offer is she pleads to those 4 and the other 3 from the different date get dismissed.
Right.
Okay.
Where it has, well, of course, where it's leeway with respect to fines.
Right, right. Okay. Do you understand the offer? Okay. Is that what you want to do today? Do you want to plead guilty to 4 charges to get 3 charges dismissed?
You talk yet? Can
Sure.
they, either some other dogs they see, they called us.
Hold on. Then let's have a trial.
Okay, but can I just say this one thing? You can make up your mind what.
No, I'm not going to make up my mind. Either she tells me she's pleading guilty or we set him for trial, and which is fine. That's what we're here for.
I'll just wait. I just really wanted to let you know that I wasn't in any way trying to disrespect when we had our previous visit in October. I kind of wanted to let them know what happened.
Right.
And how I came back to have Beaches. And yes, that I made the emotional decision I did.
Okay.
Beaches came back to me, she was abused.
Okay.
She was underweight, she had sores, and I
Okay.
couldn't. You know, I wasn't able to have kids. These are my kids, and I was very happy when they told me somebody had adopted her, but I had told them no small animals with small animals with small children. They should be teenagers, and you know that she's hyper and she needs somebody with damage, and they gave her to a disabled woman with 2 small dogs they could have.
Right.
And she had the vet records that I had given to them, and that's how I got her back.
Okay. Okay.
Just couldn't take her back, and so we gave it to my bonus daughter and my granddaughter, and so she was there for a while, and then my daughter, she had a mess, tried to take her.
Oh, I'm sorry.
So then we made Peaches back because we couldn't keep her father. Father couldn't take her to the apartment. And so he was just trying to hold on to her long enough until he even got a house.
Right.
It's just been a really emotional year.
Yeah.
And you know me from being on fire and everything. I'm not a law breaker. I'll always follow the law. I help our veterans get their benefits. I am all about community. But I just, between her having come back to me, she was 70 pounds. She's a Corso. She was 70 pounds. She's peeing all over the house. And I didn't want her to be a repeat. They take her back in and they don't get adopted, then they get to that.
Right.
They told me they were gonna put her on Facebook. They didn't. She was good to go. She had all her shots. They knew all her history. And so then we was able to get a baby girl, It's like, okay, well, she's got a home now and that's okay. She's still a family, but when Monica died, it was just a mess. So, I'm sorry, I made an emotional decision. I was in no way in any way trying to disrespect you.
We'll stop there. First of all, I'm not looking at this as any disrespect to me. Okay? And I'm sorry for your loss.
I just want them, and we can't hold on to her, so.
Well, here,
Girl gets hurt.
hold on, and we're gonna get back to what's actually scheduled today. But what I'm hearing from the city is the ordinance says you can have 3 dogs and 3 dogs only. They don't care which 3 dogs you have.
Okay.
Okay? So if there's 4 dogs in the house, they don't care if you get rid of dog A, B, C, or D. Am I correct? It's a numbers issue, right?
It's changed a little bit because there's other things going on with these dogs. They're getting out running the neighborhood, they're scared.
But it's a numbers issue. It's not a specific dog that's the problem, correct? Okay, all right. So whatever dogs you have, you can limit them to 3 and you got to keep them in control, but they don't care which specific dogs you keep and which dogs you get rid of. Understood? Okay.
It's temporary fencing because I could afford to have somebody to actually put up a wood fence, but I went and got, people were giving away, I put fencing all around
Okay.
and they haven't been getting out. My last step is to put a security door on the front because I do have 2 brothers.
Okay. All right. But today I've got 7 files. I got to do something with them. I can go along and take the plea to 4 and dismiss 3, or we can set them for trial. That's perfectly fine. That's what the system's meant to do.
I
You
take
take
the
the
plea.
lead.
I understand and I take the plea.
All right. So you want to plead guilty. So we're clear. I got 1 count of dog at large, or 2 counts of dog at large from March 18th. I've got 1 count of too many animals from that date. And then I've got 1 count of no license because of, what was her name? The Corso? Peaches. I don't know how I forgot that. So those are the ones you're going to plead guilty to. Okay. All right. And you understand your rights and options. You understand that each one of these is a misdemeanor punishable by 0 to 90 days in jail, right? And $0 to $500 fines plus court costs. You understand all that? Okay. So on that date, March 18, 2026, first of all, did you have more than the 3 dogs allowed by law? All right. And did 2 of those dogs get out and about, not contained in the house or in the yard?
I don't remember, sir, but I'm just gonna say yes.
Okay. Well, I can't accept a plea if you don't remember.
Yes, okay, yes, yes.
Let me help you. Hold on, let me help you, maybe help you. So the ticket I've got says on March 18th at 12:36 PM, 2 dogs not under control of owner, amount of dogs exceed ordinance, and 1 dog not licensed. Does that ring a bell? Does that refresh your memory? Sure. March 18th.
I think that's March 13th, Your Honor. 18th might have been when the ticket was written. But
I'm looking at the ticket, so the incident might have been the 13th,
when the incident happened.
not on the appearance ticket.
If I may approach for 1 second.
Sure.
Okay, the 18th.
Okay, go. And you,
Go ahead.
just, Your Honor, from the report related to the incident that day, it was on or about that time, this may refresh her recollection. Neighbor provided surveillance footage of ring camera of Miss Snyder in front of her house with 2 dogs on leash and 2 dogs running loose while she was calling for them. Ongoing complaints about getting loose.
Does that ring any bells, ma'am?
I have ADHD, but I don't know.
Okay.
I don't remember. I know they have gotten out.
Hold on, I got another idea. If you plead no contest, you're literally saying, Judge, I'm not fighting those charges. If I can find facts from somewhere other than your mouth that support the plea, like a police report or an incident report, I can accept the plea and move forward with a sentencing. You understand that? You want to plead no contest? If you don't have a memory, it gets us where we want to go. It gets me where you tell me you want to go, which is plea to 4, dismiss 3. Understood? All right. Would you agree that the facts I just heard from Mr. Greco established? Thank you. All right. So I'll accept your plea on 4, 3 I'm going to dismiss. All right. Mr. Greco, anything from the city before sentencing?
Yes, Your Honor, a couple of things. But I believe as part of the plea, Ms. Snyder is agreeing to be down to 3 dogs in the portions at a time in which she's down to 3 dogs.
I can do that.
Potentially, non-reporting even or probation, or not reporting probation for some month after that to being sure that there is a checking that. The reason why I say that is because I do have some information for the court with regard to the Last year, on August 25th, Ms. Snyder was here for a charge relating to the dogs. I printed out the ROA, the clerks downstairs, we have changed some things here, but that is the animal charges, the too many animals, dogs at large are misdemeanors. We had given Ms. Snyder a deal down to a civil infraction. If the court order understanding. No, actually, it was on 7/7/1.
Okay.
Defendant shall have no more than 3 dogs by October 1, 2025. And on October 1, 2025, that very day, she turned over Peaches to the City of Romulus Animal Control. Exactly on October 1st, 2025. Now, Peaches, also, the animal shelter had the dog for approximately 3 weeks. On October 23rd, 2025, the dog, Peaches, was adopted by a person named Linda Hodge, who resides in the city of Eastwood. We found the dogs in March out and about, and we recognized Peaches. So animal control did an investigation and contacted the woman that we thought that we adopted her to. When speaking with Ms. Hodge in March, prior to the issue was taken, she stated that, well, the facts here from the animal shelter are they do a meet and greet. They even did a meet and greet with her dog, Ms. Hodge's dog, to make sure this was something that she wanted. So adopted on October 23rd. Ms. Hodge told animal control that when she brought the dog home, the dog became aggressive and snapped at her husband and didn't seem to do good with her other dog, despite doing a meet and greet earlier than that. The adopter, Ms. Hodge, then stated she was scared to keep the dog the same day that she brought it home. But it was after hours, and there was no one that she thought that she could call at the Romulus Animal Shelter. So she said, looking through some paperwork on veterinary work, she saw Ms. Snyder's number on the veterinary paperwork and called her that very day. And Ms. Snyder, on October 23rd, went to go pick up the dog that very same evening. Not informing the court that something had happened, not informing the city or the animal shelter that she was brought back into the city. And it was only in March when we get a complaint from a neighbor that the animal control reviews the video, sees the dogs, sees more than 3 dogs, and lo and behold, sees Peaches from being turned over 6 months early.
Right.
Which is what generated the first set of tickets that are dated March. Some of the other ones that you dismissed today, that we dismissed as part of the deal, are dated in April because the dogs got out again.
Right.
So that's why we're here, and that is the information that we have as a city, and why we're back here today.
All right. Ms. Snyder, anything you want to add before I sentence you on these files?
I said, when she came back to me, she was in such bad shape. I was, and then we did get rid of her, but then we had the unfortunate death and we had to bring her back. I just want them to find her a really good home.
It's not their responsibility. It's not their responsibility. Your dog.
Yeah, we'll take her back to Indiana. 'Cause that's where she went to, Indiana.
You've got 4 dogs. You got to get rid of at least one of them. You got to get rid of them. We're not putting that on the city of Romulus. All right, so on each of these 4 files, I'm going to put you on a 12-month non-reporting probation. That means you don't have to check in with us. That just means I'm keeping these files open for 12 months. No criminal violations, no city ordinance violations. Specifically, whatever dogs you got at the house got to be properly licensed. They got to be properly contained on your property. All right. On each of those files, I'm assessing court costs and fines of $150. So I'm going to send you downstairs to make arrangements at the counter. They'll tell you what all your payment options are. So that's 150 times four top files that are still hanging over your head. And we'll work with you on all that. They'll talk about options downstairs. Do you have any questions? Good luck. Oh, how long to get you down to 3 dogs? Calendar's over here if it helps you.
I have the conversation. It'll give me that.
All right, so next Friday, the 19th, the following Friday, the 26th, and then the first Friday in July is the 3rd. So you're saying by the 6th of July, you'd be down to 3 dogs? Mr. Greco, I know that's almost 3 weeks out. Is that satisfactory to the city? All right, so I'll give you to after the holiday weekend, so July 6th. Yep. I don't remember them.
Something. He came back, so me and Judge Oakley had a real tips coleslaw and
I'm clean to the ball.
they came to the.
Oh, yeah. What was that for? We had clean to the bone. I did, but I don't remember what the function was. Yeah. Well, barbecue, I'm in. That wasn't community day. I don't remember what that was. They were good. All right. Good luck, folks. Hope you find a good home. Mr. Greco, are you ready on the stack that's got the name Yamut on it?
Party's out here right now. Yep, he's out here right now. Well, we, there's nothing for us.
Let's bring it in. Jeff, thanks for taking care of Cheyenne the other day. I've been walking around like this since I got the email from the guy. You know who's interested? The neighbor. The one that's already got. They originally said, no, we're not interested. And then they came back to him. So I'm keeping my fingers crossed. Sir, are you Kevin? Is it Yamut? Hello. All right. Mr. Greco, your appearance for the city?
Yes, Your Honor. David Greco, on behalf of the city of Monmouth.
I think I've got 21 files. If I counted right.
They're all in the fall, Your Honor. Yes, we're here. And the order that you.
All right.
February.
Okay.
Additional information.
And what was the February order?
So the February order, so we filed a claims motion to amend order for default judgment. And it is attached as exhibit A to the motion.
Oh, I just saw it.
Yep. And so on February 9th, we were here. So this is a property located at 30905 Beverly, Toronto. At the time, there was, it looked like work stuff, people living on the property. There was no structure there because the structures had been at that time partially demolished for the most part. There was a camper. We think somebody was living in there. There's containers, equipment, trailers, all stuff in violation of the code of ordinances that have been established through both default and citations that were issued. So we filed a motion for cleaning up the property at that time. Upon discussion with our building official, Mr. Kemp, we came in with a specific order for compliance. As the court is aware, sometimes we have cleanups
Right.
that are bigger jobs than they are. Sometimes with commercial properties, we'll see if we can assess a day penalty if it doesn't get done.
Mhm.
This is not a commercial operation, so.
Okay.
So at that point in time, we came in, I believe Mr. Yuma was here, we changed the normal 10 days to 30 days in the order. But the order was to clean up the property at 30905 Beverly by removing the storage container, the camper, the equipment, junk debris, securing, stabilizing, and making safe the unsafe structure and demolition, and shutting off the utilities, including the gas, electric, water, and sewer service. So we had but equipment containers on the property, those can be moved, cleaned up, junk and debris. We were concerned because the demolition was accomplished without getting the proper permit.
Right.
So we didn't have the proper shut-offs. And Mr. Kemp was very concerned about, we thought the water was shut off.
Sure.
Due to gas and electrical, we don't even know where it is. And we came in specifically at that time because removing rubble from a demolition is kind of a big job. We can't just send the DPW guys over there, for the afternoon to do it, or if we hire a contractor, it becomes much more expensive. So at that point in time, we came in very specifically, and my reading of this order is very specific, that all the movable stuff, we can clean up, pull out of there. If he's supposed to do it, if he doesn't, we're gonna do it. We can make safe by shutting off utilities, and we were making safe, securing, or stabilizing the unsafe structure and demolition debris there. Since that time, Mr. Kemp has been speaking with Mr. Yamut. It's been a slow go. We actually haven't gone on there and cleaned it up, but he and his father, I believe, have been moving stuff out. And there's still a pile of rubble and stuff. We did attach pictures to the motion, but I do have a photograph that was taken yesterday, if I may approach.
Please.
And what has happened at this time is that Mr. Kemp, as the building official, has been able to come into, let's say, came into some money over the last last couple of months. And there is an allocation of money available for a demolition company that doesn't have to do a demolition, but they're the experts in doing the removal of the debris and the rubble.
Looks like the crawl space is all still there.
Yeah.
So that's gonna have to be dug out, right? Okay.
And so, Mr. Kemp, the building official in the city came to me and said, well, we got this order, and we just hired this contractor to do it because we have money set aside. I looked at the order and I spoke with Mr. Kemp and I said, I remember specifically, we didn't ask the judge to remove all the rubble, because at the time we thought it was a bigger job than was necessary. We didn't want to absorb the cost that we didn't think that we could collect. So we are back here with you, Judge. Also as part of that order, by the way, Mr. Yamut was supposed to pay off some of the tickets that aren't involved before, which I don't believe that he has.
I'm still showing a balance of 6156.
Have any payments been made? No. Oh. So attached as Exhibit C is the amended order that we are looking for in the case, which is amended order for default and judgment regarding compliance and cleanup, which provides as follows. It is hereby orders that except for expressly and modified herein, all provisions of the court's February 9th order for default judgment shall remain in full force and effect. It is further ordered, the second item, that the city of Romulus, binding to its employees, agents, and contractors, is authorized to enter onto the property and remove the remaining demolition debris, rubble, building materials, junk, abandoned materials, and refuse located on the property. And further, that the city of the city of Romulus, binding through its employees, agents, contractors, is authorized to perform such restoration work as reasonably necessary following the debris removal, backfill, basically finishing off the demolition.
Right.
With the defendant, of course, being responsible for the costs, with the city being able to collect by any means available by law, including attaching any to the property or addressing it. As you can see, Your Honor, not only was the demolition done without permits in violation of the law, but it clearly falls within a blighted property under our litter, junk, debris, on premises things in us. So that's what we're asking the court to do under the authority that the court has under the Revised Judicature Act to issue any order to enforce.
All right.
And the city does have the money, by the way, set aside to hire a contractor to just clean up the site.
Mr. Kemp, do we have any estimate?
Yes, we had an estimate for $15,000.
Yeah, to finish it off, get it out, and it's a nice one.
Yeah, and that's to dig out the footings, foundations. All right. You understand what the people are asking me to do?
I bought it, it was out very,
Right.
It's costing down.
Right.
I went jail. It's 60 days about it.
You're all right. You don't have to stand up. They train lawyers to stand up. It's okay. As long as it's coming, I can hear you and she can get you in the recording. Go ahead.
I'm sorry, it's just me, and I live in a care of this, just
Which you know you can't do.
know where to go. I mean,
But this is going to sound cold-hearted as hell, and I understand that, but that's not the concern. The concern is that's not zoned for a campground.
when my deal was, I was gonna live in the camper, and I was gonna build a container. That's why I bought those containers.
I don't even know if you can build container homes in Romulus. Do our ordinances allow that?
No, that was special recommendation, and then me and Mr. Yu have had, we've
Right.
been this for about 2 years now.
Right.
But over there, he was gonna, the intent was to clean up the property, pull the demolition permit, get the disconnects, want to build a house. And we had discussed like, okay, you have to clean this up, here's the provisions, here's the, you have to do to get this in order in place. And you have tried hard to work with him to get into
Yeah.
that point, but now we're at the point where we need a lot of resident complaints and everything needs something to get placed in order.
Well, the house bowed, but it's not falling, but it just started falling.
Doesn't matter. It doesn't matter. It doesn't matter. You own the property. That means you're responsible for the structure. I don't care if it was an act of God. Whatever, you got to deal with it. And what? No, you're not. Okay, well, it's not happening fast enough. If I talked about this in February and I'm still talking about it, it ain't happening fast enough. Okay. Once again, not my problem. Not my problem. When you buy a piece of real estate, you inherit a piece of real estate, somebody gives you a piece of real estate, you've got obligations to the community that the real estate sits in. And I'm going to order that it get cleaned up. And this $15,000 is going to end up on the tax bill. And that lot's not worth $15,000.
In the process, I'm working on it right now, it's like mostly long.
Then get it done before their contractor gets there, because I'm not giving you any extra time. I don't care. I don't care. Sir, February, this is June. Listen, don't blow smoke up my ass. Okay, listen. What I'm looking at right here, all of that could have been done in February. All of that could have been done in February with the proper equipment. But once again, that's not the city's giving you, if they've been working with you for 2 years, trust me, if I was a neighbor in that community, I would be pissed at the city that they worked with you for 2 years and I'm looking at this today. I mean, I'm sympathetic, but I'm also sympathetic to everybody in the neighborhood that they got to look. I mean, you wouldn't want to live next to that.
Well, I got
Okay. You got rid of the containers. I'm signing the order, Mr. Yamut. You can appeal me, but I'm signing the order. I don't think that lot's worth 15 grand. I mean, I don't think anybody's buying lots in Michigan or in Romulus to put houses on. This gets the property cleaned up. That's my only concern. That's my only concern. Whether or not that makes the property more debt on the property than it's worth to you, then maybe you're gonna walk away from that lot. That's your decision to make. Nobody forced you to buy that lot with a house on it like that.
I didn't know that happened.
Let me ask you one question. Did you go talk to the city before you bought that lot to find out what you'd have to do with it? Yes or no? Goodbye. We're done. Goodbye. Goodbye. We're done. Do you understand what goodbye, we're done means? Have a nice day.
Why don't you get into the
Stay safe, guys. Jamie, I got the no-shows when you guys want to take them downstairs. Thank you. Heather, I'm shutting down.
Okay. Bad.
Next matter is Mackenzie Miller and Kenneth Wood, file 24-19833-DS. It does appear Mr. Wood is present with us. Ms. Spillane, can you update me on this matter, please?
Yes, sir. So there was a hearing before referee legal on May 13th where he had recommended contempt based on the fact that the defendant has not made good faith effort to make payments and that his current support balance exceeds $10,000. He did give him the option to make a $2,100 payment to not have to appear today. Mr. Wood has a monthly obligation of $703 and a current balance of $11,064.26, with the last payment received back in March of 2026 in the amount of $710.
Mr. Wood, why haven't you been making your payments?
I just started working and making money. I rent, so I caught up my bills. I supposed to have some money today. I was just going to see if you can adjourn it for a week because my boss just got a check the other day from the customer and it took 3 days to clear. So it's supposed to be cleared today. If he does, I'll come in there and pay it. But I'm just struggling right now. I'm trying to do it. But if I don't pay my rent, I lose my house and then I lose my kids. So I've been trying to catch up. I was out of work for 5 months. So if you just give me a chance, I'll have it done. I'll have it paid by next Friday.
How much are you talking in payment?
I'm gonna try to do the two. I'm gonna try. He said he could probably give me $2,000 today, just to get me caught up, and then I'll try to make the regular payments. I mean, I was out of work. There was nothing I can do.
There's a list on the whiteboard in front of the friend of the court's office of about 60 different places that are hiring. That list has been there for the entire 18 months that I've been working here.
I do work at the Frederick Inn, but that's only on the weekends. That's not even enough to pay my house. No, I build houses for a living. I work for myself.
If you're not building houses, you need to have another job. That doesn't give you the right
and
to just sit at home.
I just landed a nice job. It's with Mackenzie's uncle, and we've been working every day. He's trying to help me get caught up. We just started getting the money rolling in. So I'm sorry I had to wait for the 3-day clear on the check. I didn't know he had to wait or I'd had the money today.
Okay, Mr. Wood, I'm not as concerned about waiting a week when you're employed. What I'm concerned about is that you were not employed for 5 months and you didn't make any payments during that period of time. You can't just sit at home.
Your Honor, I'm not. And I just got kicked out of court because me and her were supposed to come into court on an agreement. And then she told me not to show up for court. So I didn't. And she showed up and they dismissed it. I was going on off of what she'd been telling me, and I have gave her money, and I don't get to see my kids. I don't get to see my kids at all. She lets me see my kids for a weekend, and then she turns around and presses charges saying I'm touching my kids and stuff. I'm going through it now. I just got out of the courthouse yesterday for I have to take a lie detector test because she's making false accusations again. This is the 3rd time she's done it to me. Like, why am I the only one that's getting penalized here? You know, when you pay child support and
Mr. Wood.
What?
Slow down. Parenting time is not connected legally to your obligation to pay support. If listen to me first and then I'll let you talk. If you have a parenting time issue, that's addressed at the friend of the court's office through a parenting time or a custody motion.
I did that.
Today is not about that. It is about child support. That is an obligation whether you see the children or not. The two are not legally connected.
I understand that, and I went through hard times, and I'm coming out. I got a decent job. I've had a lot going on in my life. It's not that I'm not wanting to pay it, but if I got other obligations to pay to keep my house so I can have my kids. So yeah, I just caught up on a lot of my rent and stuff. So this next paycheck was coming to her.
All right, I'm going to give you an opportunity to show me those things.
I'll show you. Just give me the opportunity. And I have been 3 times. I've asked the court to lower my child support because I have not the unemployment that I used to have. And every time I've asked for a lawyer, you guys have jumped it up another $1,000. I'm asking for to be lowered a little bit so I can make the payments. And this is the third time I've been in front of you, and it's been jacked up higher and higher and higher. You guys not even working with me to help me lower it. I was working at the bar on the weekends just to make money so I could give her a little bit of money. You know, now I'm working full time. I just need to get out of the hole. I've always paid my child support. Look at it. I paid off my daughter's child, my 18-year-old. I paid off Kylie's child support. It's not that I don't want to pay child support. I just came into a deficit where I almost lost everything. And if I lose everything, I lose my kids, and I can't do that. I'd rather pay my rent than child support because she just got $9,000 from taxes. She's not hurting for money.
Mr. Wood, every time I start to try to talk, you keep talking.
Sorry.
If you wish to contest the amount of child support, file a written motion. The friend of the court will review it. We will have a hearing and a decision will be made. But as of right now, you owe $11,000.
Yes,
in arrears.
I know what I owe.
So here's what's going to happen. We're going to give you a week. You're going to come up with a full payment of $703 in that week. If you fail to do that, we're going to have a hearing next month to make sure that you've made that payment.
Okay, I'm down.
If you have, we'll adjourn it another month to make sure that you continue to make your payments. If you haven't made your payments in full, we'll have a hearing on whether or not I send you to jail for 7 days. And every month that you don't make your payments, I'm going to have a hearing and decide whether I send you to jail for 7 days. And we're going to get out and do that all over again until I can see a pattern of paying.
I got you.
The last thing I'm going to say is this. This should be your busy season, right? This is construction season now, so you should have a good job and make your payments. But you've got to have a plan for the wintertime when you're not in construction. You've got to have a secondary job. You can't say, I'm just going to go on unemployment, or I'm just going to not make my payments, or anything like that. You've got to have something else coming in, and you've got to have a plan for saving some money when you're making it good so that you can pay when you're not doing well. Do you understand that?
I understand that, but I ran into some problems. I've had court issues. I got $4,000 in fines in court. So yeah, I've been catching it up. I'm working on it. I do that. Hey, can I work at the bar on payroll. Can I use that as so they deduct that out of my paycheck?
Yes, you can. You can get an income withholding from any employer that you wish.
Okay,
Mr.
I'll
Spillane,
get that.
what does he need to do that?
Okay, I'll get that done today.
I can start that today.
All right. So you know how to get a hold of Ms. Spillane, Mr. Wood?
Can I get her number?
Yes, my direct line is 989-731.
Okay.
7471.
7471.
Yes.
Okay, I'll call you in a few minutes. Thank you.
That's all for today.
All right, appreciate it. Thank you.
All right, good afternoon, everyone. Sorry about the wait. We had some technical difficulties here at the courthouse. Apparently, nothing wants to work on a Friday afternoon. So, call the matter of Joshua Borden, file 25-11226-MI. I do see Mr. Borden is with us. Mr. Delaney and Ms. Brucker are here. I believe we're here last in March, and then things were continued a couple of times to today's date. At the last court hearing in March, I asked for some briefing on the issue of the religious objection to the treatment or potential treatment. Both parties have submitted documentation for that. I've reviewed the prosecutor's memorandum and Mr. Delaney's submission as well. I'll take argument at this time. Mr. Delaney, go ahead.
Thank you, Judge. The court is aware that this is a First Amendment issue, being the bedrock of the founding of our country. And the issue is the government mandated medication. And I know the court a moment ago said treatment, and that is a broad category. I do not think that Joshua opposes the treatment, the counseling, those types of things. What he does oppose is the involuntary ingestion of medication because it opposes his religious beliefs, his freedom of exercise. So there has to be a compelling state interest. And I know Joshua was here and he's listening, and I think that's the distinction, and I'd ask him to object if that's incorrect. So the counseling was good. I know he was involuntarily hospitalized, and I think that that would be within the purview of the court. But it's that medication. And so, as the court could tell from the briefing, we don't have substantial case law in the state of Michigan. We have some other states, we have some federal law, but I do think that the state and I agree on the prevailing principles for the court to look at. And I cited the Milton case out of Ohio, and I recognize that the vast majority of the cases deal with the patient's physical treatment. Now, I don't want to have the hospital perform surgery. This is mental health treatment, but I don't make a distinction between the two because they are both related to the health of the patient. And I think the two areas where we agree with the state is that my cases say grave and immediate danger, and even the state stated imminent danger or threat to himself or others. And that's the same principle. I also agree with their clear and convincing evidence standard in this case. So using that principle, the state is going to have to show that there's an imminent danger to himself or to others relative to the taking of this medication. And the only thing they cite is an August 2025 report. Well, that's 10 months ago. They need to come to the court now and say he's an imminent threat to himself or to others unless we involuntarily ingest him with this medication. And I think that that captures the issue in this case. The court would have to know that. And so the final analysis is, what does the court do if it finds a compelling state interest and imminent threat to himself or others now, right now? What does the court do? Well, the court's well aware that we vest the courts, the government, with the power to enforce its orders. You start with a show cause. You could or could not hold that person in civil or criminal contempt. You can impose fines, costs, and then jail. And the jail is either to punish the contempt or hold until there's compliance. And those are the powers of the court, which are strong, and we want them to be strong. But that's what you would need to do. But would the court do that? If the court had the finding, perhaps. I mean, would the court jail someone in this case because they weren't taking their medication? But that doesn't solve the problem, because now they're jailed, but they're not taking their medication. So we get to the debates that we had during COVID. Does the court and the government have the power to literally strap someone to a gurney, really, and inject them with the medication? But that was hovered about during COVID. Can we do that? And I don't think the courts ever really got to that point in this case. But that's what would have to happen. But what you're up against is the First Amendment. And then versus harm to self, harm to others. That's a compelling state interest, I think so. But the test becomes imminent danger or threat. And I don't think you have that. In fact, Joshua's case I was assigned to this back in 25. We've adjourned. It doesn't look imminent to me. He's here. He hasn't harmed himself or others. That can change. Mental illness is an unpredictable feature here. And then finally, Judge, I wanted to indicate that the courts distinguish between competency and mental illness. Just simply because a person is mental illness, it does not mean that they do not retain their civil rights. They do. If a person's incompetent, which is a high standard, the court gets that challenge all the time. I was incompetent. You don't have that here. No one has said that Joshua is incompetent. We can speak to him today. He's lucid, I think. Mental illness is a different issue. So the court has those layers here. And the issue is imminency, and the state has not shown that. Thank you.
Thank you, Mr. Delaney. Ms. Brucker?
I don't have a lot else to add beyond my brief, but I would note a few things. Community Mental Health essentially did bring this to the court by filing this second petition for treatment, and that's why we're here. So it's not as if they haven't brought this to the court's attention, and they brought it to the court's attention because Mr. Borden had made statements to them that he did not intend on continuing with his medication unless there was an order from this court. I reviewed the cases that Mr. Delaney provided, and I think there's a little bit of a distinction in those cases. Obviously, people have the right to voluntarily refuse medical treatment. But these petitions that we have, these MI petitions, are a little bit different. In almost every case of these that come before this court, the individual does not recognize their need for treatment and does not want to voluntarily follow the treatment. So the framework that's set out is already a little bit different than those cases, and it anticipates someone that does not want to participate in treatment. That's all I really have to add, Judge. And I guess the other piece, it seems like Mr. Delaney's alluding to a little bit that there's not enough information in the certification or petition to determine whether or not he's imminent harm to himself. That's usually what we are talking about when we hold the hearing. And so that's something that we would decide whether it's a hearing in front of you or whether we end up having a jury trial on this as well.
All right. Thank you both. I do appreciate the research. I was impressed by both of you in the way that you brought that to my attention, and I do appreciate that. I think what I'm going to do, though, is put a little more fine point on the research that you did. And I believe that we're not yet at the appropriate place to make the First Amendment argument. Where we are right now is whether or not we have a jury trial on the issue of whether or not he is a person requiring treatment. The statute is clear, whether it's a first request or whether it's a continuing or second or subsequent request for additional treatment. The person that's involved in that, the respondent, has a right to a jury trial, but that right is limited to whether or not they're a person requiring treatment, not what is the extent or the involvement of that treatment. And let me lay out my research for you and see if there's any issues that you can, or questions that you have about that. The issue of jury trial, the elements of what is necessary to be proved under the civil jury instructions for involuntary treatment for a person requiring treatment say that the elements that need to be proven are whether or not the person is mentally ill, number one, and then number two, that as a result of that mental illness, they can reasonably be expected to seriously physically injure themselves or others. They are B, unable to attend to the basic physical needs, or C, they lack understanding of the need for treatment and to present a substantial risk of significant physical, mental harm to themselves or others. So the issue is, are they a person requiring treatment? Because those are the three parts of the definition of that. Nowhere in the jury instructions is it shown that I have to prove, or that it has to be proven, what type of treatment results after that. So that's my first authority for that. I turn to the statute, MCL 330.1458, and it says that a respondent has the right to demand a jury trial on the question of whether he requires treatment, not on the question of what that treatment is. Similarly, for a second petition under MCL 330.1472, it says upon a finding that the individual continues to be a person requiring treatment, then the court shall issue a second order for involuntary mental health treatment. So there has to be a finding first before I can require him to do a specific type of treatment, which is really what he's objecting to, is the type of treatment involving medical injectable type materials. Similarly, under section MCL 330.15, 18, and 15, the court is required to enter an order, but it must review a report and recommendations before ordering the disposition. And I think that is the part of the process where what Mr. Delaney is asking for needs to be done, that assessment. But that requires a finding that he is a person requiring treatment first, and then there is to be a report done by community mental health recommending specific types of treatment for him. And then if he objects to those specific things, then I would go through the process that I think Mr. Delaney is trying to outline, and Ms. Brucker has also outlined as well. There's also a specific Michigan Court of Appeals case, In Re Portis, 325 Mishap 374 from 2018, which says this is a two-step process. It says that the jury decides the issue of whether he is a person requiring treatment by clear and convincing evidence, and then the court decides the type of treatment by a preponderance of the evidence, and the court must consider first alternative treatment program report, and then whether or not the defendant desires or what his desires are concerning that alternative treatment program. I would also note that under MCL 330.1752 subsection 1G, the mental health code does speak about treatment by spiritual means, such as a religious objection, so that is allowed. And then the court would then have to decide what is the specific religious objection and how does that relate to the alternative treatment that is recommended. So what I'm going to do today is punt the ball down the road. I don't think that today's issue, which is whether or not we have a jury trial or a bench trial on, is he a person requiring treatment? That is he mentally ill? Is there a substantial likelihood that he's going to endanger himself or others? That's the first question. Once that has been made, and he can either ask for a jury trial on that issue, or he can ask for a bench trial, or he can willingly submit to that portion of it, and we would then preserve his right to object to any alternative treatment program that's recommended. Once I receive that report, and once we've determined that he is a person requiring treatment, then I can specifically say whether or not there is a imminent risk of death or great bodily harm or a danger to himself or others under the statute, and then make a specific determination of what, if any, recommended treatment would violate his religious beliefs, and is there a workaround or a state interest that would require that. So that's what I propose in this case. Counsel, Mr. Delaney, any thoughts on that?
Well, hold on, Joshua. I just want to say first, Joshua, that I know the court covered a lot, but you should take from that the court spent a significant amount of time researching this and is definitely looking out for your interest and the state's interest. But before you speak, Josh, I just want to say that, things you say to the court, the old saying, can and will be used against you. So did you just want to address the court on the jury issue? Is that where you were going to go?
I'm wanting to object to treatment entirely. Counseling and the injections and the medications, I don't believe they're needed. My religious rights, I believe, are relevant to my case for not wanting the treatment.
Okay, so that's a bit of a modification of our prior discussion, but consistent with it, Judge. But I think his statement would still fit into the court's approach to addressing this. And if I could inquire of the court, what would be the next step that the state would have to, you'd have a hearing before the jury trial on whether he is a person that requires treatment? Is that the first step?
No, we would have a jury trial. If he wants to have a jury trial, the next hearing, in my view, would be whether he's a person requiring treatment. That is he mentally ill? And does he meet the statutory definition of a person requiring treatment? And that has three portions of it that I read earlier. Is he reasonably expect to be seriously physically injure himself or others? Is he unable to attend to his basic physical needs? Or does he lack understanding of his need for treatment and present a substantial risk of danger to himself or others? Those are the three reasons why, if he's mentally ill, and is he a danger to himself or others? That's the only issue that a jury can resolve. Now, he's entitled to a jury trial, or he could choose a bench trial, or he could say, I agree that I do need treatment, but I'm objecting to the specific parts of the treatment, such as counseling or injectables or whatever. But that's a separate issue. What type of treatment, as opposed to, do you need treatment? So is he a person requiring treatment is the first question. If you wish to have a jury trial, I'll simply schedule it for a jury trial. If you wish to have a bench trial, I'll schedule it for a bench trial. If you wish to give the court jurisdiction, and then it'd be like in the juvenile cases, adjudication and then disposition. So we got to do the adjudication first, and then we get to the specifics of what does that entail after that.
That's what I thought the court was saying, the two-step process, which I equated to a juvenile case, adjudication, then disposition, because that's probably closer to that than conviction, then sentencing. So let me, and before I give the state a chance to weigh in, although I think they're in agreement with the court's process. So Joshua, you would get the first part answered. That is, they have to make a finding that you need treatment. And to do that, you have a trial. You have the right to a trial. You can have a jury trial, and I think it would be 6 citizens here would come in. Correct. And they would there'd be 6 people that know nothing about this case. They live in the community, and they hear both sides and tell the court whether you need treatment or not. And I'll come back to that in a second. Once that happens, then the court gives you a second bite of the apple. Okay, what kind of treatment? Counseling, medication? You get a second opportunity without a jury this time to decide what's appropriate. And then the court would address all of your religious objections to anything that the state was asking for. So basically this, Joshua, prove it. And if they do, then the court's going to look at what to do. Okay, so let's go back to the first one. You can have a jury, or, and it wouldn't be today, of course, or Judge Hasselink would hear it by himself with you in the courtroom and everybody else. So that's what I'm trying to say is, do you want a jury, or would you like Judge Hasselink to be the jury, if you will? Or do you know?
And if you want additional time to speak with your attorney, rather than have to make a decision immediately, I would certainly grant you that opportunity. In fact, why don't we do that, Mr. Delaney? I'll simply, would a week's period of time be sufficient?
Yes. Joshua, are you back in Gaylord?
No, I'm not in Gaylord right now.
Okay. Do you have a pen?
Yes, I do.
Or do you have my telephone number, my office number?
We have time on July 7th.
All right. And you have my email. So let's do this. After the hearing, I've got some other things to do, but we'll have a week. Call me or email me and confirm your current telephone number. And then I'll call you like I have before. Okay. And we'll discuss the jury trial issue. And we have a week to do that. Okay.
Your Honor, if I could speak.
Yes.
I don't think I need a week to decide that. I think what I'm willing to have you do is you decide. You be the jury, and you decide whether I need treatment or not.
Okay, I'm happy to do that. I just wanted to give you every opportunity to discuss it with your attorney so that you weren't rushed into making. I didn't want you to feel like you had to make a decision immediately and you didn't have time enough to consider it and think about it. So what I will do is I'll have my staff find the appropriate amount of time in my schedule, and we'll schedule it as quickly as we can thereafter. Let me check with Ms. Brucker first to see if there's anything else that we need to consider.
Okay.
I don't think so, Judge. I agree with what the court's laid out.
All right. So I will have my staff send out notices for the next available date for a basically a bench trial. A trial in front of me as the judge to determine whether or not you're a person requiring treatment. Counsel, would a 2-hour block of time be sufficient for your needs, or do you think we need a little bit more?
Does the court, I'm sorry if you said this, does the court intend on hearing both the first part of the hearing, and if the court finds enough evidence for us to proceed to the second part at that date, or?
No, I'm anticipating just the first part. And the reason I say that is because I would like to have, once that's determined, I would like to have a new report. I think the statute requires a new report because to Mr. Delaney's point, that hasn't been done in a long time. Basically, it had to do with the first orders that he was done. So I want a new report if I find that he's a person requiring treatment. And I want then that report to go to Mr. Delaney and Mr. Borden so that they have sufficient time within which to decide what pieces or what parts of it they want to object to, if not all of it, but and be specific about the religious beliefs and why that's tied into those kinds of things. So I want that to be had sufficient time to do that because I think that's a very important piece. So it will be only as to whether or not he meets the statutory definition of person requiring treatment.
I think 2 hours is plenty. Yep.
Mr. Delaney.
Let me just delve into that for a moment. And I do think counsel and I are, hopefully, we've worked on being more brief over the years. How many witnesses will you be calling, Ms. Brooker?
I know we'd have the doctor, but I know there have been a couple of changes of caseworkers, so there might be a couple of caseworkers since they filed that petition. But that would be it.
Okay. Joshua, do you have any idea of if you'll have people come in and testify for you, your dad, a friend, a professional, your own doctor, yourself? Do you have any idea that you're not required to? The state could just have to stand on their own proofs, but do you think you would present yourself and other witnesses?
I don't have any other witnesses that would be able to come in. I mean, maybe my dad, but
all right. I think 2 should work. I know the court is reasonable, and if we went over or if something came up and we had to continue, we would do that. But I think from what I've heard today, 2 hours would be appropriate.
All right. I will have my staff then do that as soon as we can find a 2-hour time block. And once that comes in, obviously, if there's a conflict with your schedules, let me know as soon as possible. But we'll try to pick something that fits everybody's schedule. And I think in person would probably be well, I don't know where your experts are from. So do you want to do this in person? You want to do this in person or via Zoom?
I'm sorry, Joshua, are you out of state?
Yes, I'm out of state right now.
Okay, so we'll probably have to do this by Zoom. Is that okay? The trial? The judge is offering you in person, so you'd have to come back to Michigan. And of course, I always recommend that. But you know, if you're in Montana and you can't get back, and the court's done both a long time, you would still have a fair shot either way. But I prefer in person. But if it's not practical, we could do Zoom. Get some thoughts about that?
In person.
Okay.
All right. So we'll set it up for in-person 2 hours as soon as possible.
Your Honor, would the
ahead.
court allow Dr. Gehrman to appear on Zoom? I just know that's going to be a scheduling issue if he has to be here in person.
Yeah, I believe that most experts need to have the Zoom option available. If there's some fight about that, Mr. Delaney, let me know. But I think that is pretty standard given their schedule and their need to have other people available to them and for them without having to drive all the way here and drive all the way back to their office.
Your Honor, if I could speak real quick.
Go ahead, Mr. Borden.
Would you give me more time to go find another opinion, seek counsel?
How much time are you looking for?
give me a couple of months.
I can't do that.
Can't do that.
No, the attorney that you have is probably the most experienced attorney in this area on these issues. And so if you want, you always have the right to have a second opinion.
No,
But
not
I can't.
an attorney, counselor. As far as another doctor.
Thought he meant that, but I'm always ready for the, I need a new lawyer.
Well,
Get that too.
okay. You have the right, I believe, to have an independent examination if you wish. So we can, if you do that, you would still remain subject to the current order. And that means that you would have to take the medications and the requirements of the current order while you're doing that. So that's, if that's what you're going to ask me for, I can grant that, but you're going to be subject to the current order and the current requirements until we have another hearing and determine whether or not you are a person requiring treatment. So that's the downside to making that request. So if you want to do that, I will grant you the requirement, the ability to do that. And I'm going to ask you to do it as quickly as possible. 2 months may be a little long, 30 days to at least get the person and then make a determination of how long they think they need to get up to speed. So the ball's back in your court as to what you want to do.
Yeah, let me go get another opinion.
All right. In 30 days, I need to have a response. So here's what we're going to do. I'm going to set this for a status conference in approximately 30 days. You can then tell me through your attorney whether or not you have another doctor to give a second opinion on this issue. And if he needs any additional time, how much time he does need. And then we will set the jury trial, the bench trial for that time period that allows him the time that he needs. But I'd like to have him as quickly as possible in place and start looking at stuff to tell me how long he's going to need before he's ready. So I'll see everybody at a status conference in approximately 30 days, and then we'll set the bench trial once we get to that status conference. Any other issues that anybody else has?
No, Your Honor.
No, thank you, Judge, for your time today.
All right. I'll see everybody in about 30 days. Good luck to you, Mr. Borden.
Thank you.
Okay.
The first case that I believe is ready is Giles versus All American Services. Okay. Yeah. Would you mind having a seat there at the table? All right. And you're Rebecca Giles? Okay. And then All American Services. Can I have you turn on your camera and microphone, please?
Mike.
All right. And are you Denise Wise?
Yes.
All right. Thank you. Okay. And this is, 39477. Court file here. Here we go. All right, so Ms. Giles's claim for it's like principal amount of $6,000 based on a plumbing job. All right. All right, is everybody ready?
Yes.
Your Honor, when we went to mediation, I changed that to $3,000, dropped it down.
I may be looking.
We had Rodney, deputy prosecutor. Isn't that correct?
If that's all you want to claim, this $3,000 is fine.
You know, plus all the service and all of that.
Yeah, other costs, allowable costs.
And it did make it to $3,000. You know, being lenient. And
All right. Well, we're gonna get into this. So I'll give you a little orientation as to how this will go. So let me double check here. Yep. Double checking for a counterclaim. Okay. So what will happen is I'll swear the parties in. Plaintiff will go first. Ms. Giles, you're the plaintiff. And you can explain your claim. That means your testimony. You can refer to any exhibits that were properly filed in the court file. And if you have any witnesses that you want me to hear from, I can swear them in and hear from them. After the plaintiff's had an opportunity to present her case, it'll be the defense turn. And same process, you'll testify about your case, refer me to any exhibits that have been properly filed in the court file. And if you have any witnesses who you would like the court to hear from, I'll swear them in and hear any testimony that they have. After I've heard from each side, I will hear from each side once. We won't go back and forth. Then I'll make a decision. I'll explain to you why I made the decision that I made. I'm going to ask you to follow a couple of procedural rules here, even though these are informal proceedings. While the other party is telling me their side of the case, please don't interrupt them. Even if you believe that they're telling me information that's inaccurate, not true, whatever, just let them tell me their side of the case. Keep in mind that you will get your chance to tell me your side of it in a few minutes, or you've already told me your side of it, and I know. I may need to ask questions from time to time, so I may interrupt you to ask questions. And the reason I would do that is because I want to make sure that I understand the nature of your claim or the nature of your defense. I'll also do that to keep matters focused on the facts and issues that are going to actually help me to decide this case, rather than maybe some issues that are tangential and don't really get us any closer to where I can resolve the case for you. All right, with that in mind, I'm going to have all of you raise your right hands, please. And do each of you swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
yes, I do.
Okay. All right. Ms. Giles, you are the plaintiff, so go right ahead.
okay, Your Honor, I hired. I'm here on behalf of my father. I'm sure you've probably read through this already. Who has very advanced dementia. And I was getting this property ready for resale because soon my dad would have to be in a home. And I didn't. My original plumbers were unavailable and couldn't come at the time frame that I needed. So I walked down the aisle in the trailer park where my dad lived, Tumwater Estates, and I ran into a gal by the name of Barbara Stahl, and she had hired them to do some work. And I said, well, did they do, how did they do? How was the price and so on and so forth? And she just said, well, Paul was gruff and he did a reasonable job, but his price was high. So I figured, he did a reasonable job. It's just a PEX repipe, water in, and we would do that. So I gave him a call to discuss replacing the plumbing in the 2 bathrooms and to remove the garbage disposal in the kitchen, replumb the washer, and replace the hose bib outside. The hose bib will be the important part of this particular case. So please remember that. Paul wanted to charge $10,000 for a PEX repipe, and I told him no, and he came down to $6,000. I figured, well, I need it done, so I'm just going to go with that. And then when he came, he said, why just do these, why not take, all of the old plumbing out and repax the whole thing? And I said, for the same price, and he said, yes. So I said, go for it. Mr. Wise, the plumber, is like 6'4", 280, and he could not get under the trailer. So he brought in some other people. I think they were related to each of them. So when he came, we talked, and then so he came back and he told me that he forgot his wallet, so he couldn't start, and that could I give him any money up front? And I said, no, I was taught to, not do that, just to pay when the job was done. So, sorry, I have dry mouth here. And so he just, kept, bugging me. Well, and I'm just like, okay, it's, I'm gonna have to find another plumber then. And so he said, well, maybe I have a credit or something at this plumbing store. And so he agreed to do it. And the next day he came back and he told me that he was going to put the PEX through PVC piping and put it on the outside of, excuse me, the outside of the house. And I'm thinking to myself, that is incorrect. You can't. I mean, it swells. It's eventually going to crack, and it needs to be under the house and wrapped. Hung and wrapped. And I called my brother, who also does plumbing in Alaska, for some guys, and he said that's completely out of the question. No PVC on the outside of the house. So I went to the store and bought some groceries, and when I returned, Paul and his nephew, or Denise's son, I think, was there working under the house. Not Paul. Paul couldn't get under the house at that time. I decided to look him up under the BBB, the Better Business Bureau, and there's an exhibit here that shows that his company was an F with the BBC, and there were other. I read some reviews, and there was one review that was similar to almost verbatim to what I am going through now. So he goes, oh, you've been reading, reading. And I said, well, no, at that time I hadn't. I just looked him up, and, and he in the business had an F. So I'm like, oh boy, here we go. So it was not longer after that, after he started yelling at me. He yelled at me early, and it frightened me outside, because I'm going to go back. He had put a hole underneath the sink where I had just laid a new bottom to the sink. And he had put a hole in a place that didn't need to be. So I asked him about that. We're outside. His voice escalated. And I said, I'm just, I said, calm down, just, I need to understand you. You need to understand me. And I don't appreciate being yelled at. So on, let's see. So I asked him if he had a permit for this job. And that's just my, these, I'm not a professional at, hiring people. So I asked him that. And he said, "Oh, you're gonna make me pull a permit, huh?" So went to City Hall and pulled, got a permit. And he also had to get a license to work in Thurston County. He didn't have a license either, so he got that. And let's see, on January 22nd, he put, so after he did the plumbing and all these, I'm sure you've seen these, or do you need me to hold them up, the pictures?
You can just refer to them by exhibit number. You should have had them
Yeah, I
numbered
do.
before you submitted them.
Yeah, they're all listed. So exhibit 1 was the F. Exhibit 2 was where I paid him the check on January 22nd to be done. So let me go into the next one. It was not long after that I paid him that my dad needed to use the restroom. So it immediately overflowed, where before the plumbing job, it hadn't overflowed. And so I tried to clear it, wouldn't clear. I called Paul and Denise to try to, and they told me how stupid I was for not knowing that the water intake and the water out were 2 different things. I know that, of course. That's where the bib comes in. So I didn't know what to do. The next day I contacted City Hall, and they sent me to a gal named Kelly Wallace in the Community Development Department for the city of Tumwater, and asked what I needed to do. She said she would send somebody over right away. And it happened to be within 10 minutes, Mr. Eric Hyde, a building and fire safety official, and Al Christensen, the head of the department, showed up. Mr. Hyde and I went under the trailer and found the PEX was laying mostly on the ground. It was not hung properly. It wasn't hung at all. Some were hung on beams or just, laid on beams. And where he turned or where he put in a on and off, turn off and on, so that you could do it underneath the house. It was just laying there. And originally I thought that it had come from the water was leaking from that, but it was actually leaking from the toilet that overflowed. That is exhibit 3. So the inspection report was exhibit 3. So Mr. Christensen, while he was there, asked if I had another plumber. I said, I do, but he would have to, he, as in Mr. Christensen, would have to coax him to come over, because he told me that he was on another job and couldn't be there until the following Thursday. So I called Mr. Davidson at Kairos Plumbing, and Mr. Christensen took it from there. He just said, hand me the phone. So I handed him my phone, and he spoke with Mr. Thomas and told me that I needed to order a honey bucket for the trailer, get him a portable potty for his bedroom, buy hand cleaner for every room in the trailer, and do it now. I did. They did not red tag the trailer. When it's pertinent to note that when Mr. Wise, the plumber, finished, it was dark, and I wasn't going to go underneath the trailer to inspect it myself. My dad didn't have a flashlight that worked, so I, my phone had been acting up, and so my flashlight wasn't working because my dad doesn't have service in his, Wi-Fi service in his house. So the next day, the outfit that was caring for my dad 5 hours a day, 7 days a week, turned me into APS because the toilet, my dad doesn't know the difference because he's got, to use the honey bucket, he just, it was beyond him. He didn't know how to use it, even if you took him there I took him there personally to show him how to use it, and he couldn't get the concept, and he also couldn't get the concept. This is the first time that I had to put a porta potty, indoor porta potty, a sit down in his bedroom that he wouldn't use either. So he kept using the toilet, kept flushing it, and the water just kept coming down outside. So they turned me into UPS and had a staff member then came to interview me. And it turns out that they cleared me of, when the guy came, he tried to interview my dad. And of course, my dad doesn't know what he's talking about or saying. He does know how still to get up, and if he was to walk up to you and shake his hand, he would say, "Hello, sir," and that's pretty much what he can do at this point. All he can do. He's moved to a home now. So the next, so then on top of all of this, the advanced care health place quit. So I asked when the APS fellow came in, I said, "Do you smell any defecation? Do you smell any urine?" And he said no. So it was another, month before I got it back. And so my dad, it turns out that it wasn't a coincidence, but my dad had to go to St. Peter's and because his kidneys were not functioning, they were not clearing out. So Kairos Plumbing, Mr. Davidson, the damage to my reputation was worth more than anything. Kairos Plumbing, Mr. Davidson, and staff came with permit and license in hand, pulled the toilet and put a snake through. What I didn't write in here, because this was my first rodeo, is that I called them several times. I even went and got my phone records from January 8th. I just went forward to February 10th or something, so that I could, show myself that I did call them several times. I think it was like 6 or 7 times going out, call them. So to come back, and I said, maybe go up on the roof and go through the vent and put the snake through the vent. And I didn't get a phone call. Then they called back and said, this is not an issue of the sewer line. And I said, it is an issue of the sewer line. Because when he dug down in the evening, when it was dark, he exhibit number exhibit number 4 and 5. You can see the snake coming through. Whoever put this, put the sewer line in, and the hose bib is right next to it. So, well, actually, you can see the blue right here, Your Honor.
Mhm.
That
I've
goes
got
up to the
exhibit
hose
right
bib.
here.
And so Mr. Davidson went to the farthest toilet and pulled it and put the snake through, and you can see that that it had been severed already. And that is the coincidence that is not a coincidence, although I've been told in mediation that was that Mr. Davidson is the one that ruined that, and that is not the truth. So Mr. Davidson put in exchanged that with an RBS or RSB, I think it is, piping to connect to the sewer that was right next to the hose bib. And instead of fixing what he had broken, Paul just took this $6,000 and left. Denise said, well, yeah, Paul had to dig down 4 feet. And the only place he had to dig down was here. There's no other place that he would have to dig down because all the piping was underneath the trailer and cut out. So that's the place that he would have, the only place he would have to dig, Your Honor. So Denise continued to call back. Denise kept calling me saying, that they need to be able to come and fix it, blah, blah, blah. And I called the city and told them that, the job was done, or I didn't call the city. Kairos took the information over to the city hall and said it was complete. So Mr. Hyde came back. I went underneath the house again, the trailer again with him, and it was completely hung correctly, and it was all insulated, and the ABS pipe that was connected to the sewer, which this wasn't a sewer job, but it ended up being a sewer job. And I had to pay another $4,845 to Kairos to take care of all of that. And that is Exhibit 7. $4,845.59 to take care of that. So on July 3rd, I received a text, Exhibit 6, from Paul Wise, that I interpreted as it was an apology. He apologized. That's here, and you have it as well. I interpreted that as, I did you wrong, and so that is basically what it is. Yeah, it wasn't originally, it was just an inside. He forgot to plumb the washer as well. We had an add-on, and he said he didn't know anything about it, but yet when I was there the next day, because remember that outfit that was caring for my dad quit. So now I was down there, 8 hours a day, and there were red PAX 5 hanging over a line in there. So he had been in there. That's where the washer and dryer was. And so he didn't do that. My bad. It was late. I was tired and I didn't check the work. So that's my fault. And that's one of the reasons why I dropped it down to $3,000. In mediation, they told me, or he told me I wasn't going to get it done. So that's all I have. If you have questions, please ask.
So I noticed that you did not submit a contract with your exhibits.
Contract? No, there wasn't. There
Was
wasn't a
there
contract.
a written contract?
No,
Okay.
I didn't receive one.
So you,
It was a handshake.
so your testimony is just your understanding of what your agreement was with the defendants.
Yes. I mean, Paul and I shook hands and said go. You know, I mean, it's really for a plumber, you know, cutting out, you know, the old galvanized and putting in new packs is really not that huge of a job. He was just too big. He was just too big to get under there. And maybe the young kids, I don't know if they had license or if they were, I don't know. I don't know any of that.
Okay, let's hear what All American has to say about the situation. All right, so All American, I guess you two can decide between yourselves who wants to go first.
Your Honor, thank you. I'm going to just read to keep my thoughts organized. And we submitted this as a submittal packet to you, so you have all the information.
Video cut out there.
Oh, okay.
Okay, yeah, your video just cut out. So go ahead and start again.
Okay. I'm going to be reading off our submittal packet that we submitted, and it should be in front of you. Just to keep
you don't have to read what you've already submitted. If you've submitted this in writing, which I see you have, it's not necessary for you to read it. It's already part of the record.
I guess then what we want to clarify is we are fully licensed, bonded, insured, have always been from, and we did have a contract with her. So.
In this matter, sir?
Okay. So I've,
Marta's not going to talk.
yes, what I need to know from you, you heard, the testimony regarding what the agreement was and the work that was performed, and you heard Ms. Giles's testimony as to why she believed that she didn't get what she contracted for. So I'd like to hear your response to that.
Your Honor, she did get everything that we had on our contract, our estimate for the job. We did a full repipe on the water lines. Anytime you run into galvanized, it's best to just get rid of them. It's an old pipe. We did a full repipe on the job. We pulled a permit. We started running into trouble with her, and we finished the job, and she was just going over everything. And it was frustrating because from the beginning, all I kept hearing is, my plumber does this, my plumber does that. Well, your plumber can't be here for a while. So you hired me. Let me do my job. Let me do it and you'll get a good job. We butted heads a bit, but at the end, when I finished the job, we were okay. And 3 days after, a week later, we get a call that the toilet is backing up. So I do go out there to check it out, but it's another part of the job. It's not part of the repipe at all. This is a sewer pipe. And Denise explained that in our submittal packet. We have the emails where we explained it. And so this is another part of the job. And the invoice that she had submitted from Kairos Plumbing just solidifies that fact. It is a different part of the job. They charged another $4,000 to fix a pipe. Now, I didn't dig down 4 feet at all to do any water piping. I got the water line and changed it over to PEX. There's no sewer line that is corrugated pipe. I've never seen that in my life. That's what you see in her picture. And he's got a 3/8 cable running through a 4-inch pipe. It makes no sense to me that that's what's going on there. And I don't know what's going on there because I didn't see any sewer pipes underground when I was working. I was focused on the water lines, and that's what we ended up doing. And going into this, and when we went into our mediation, there's zero proof of anything on this sewer pipe. I never saw one. I never heard anything about it. The hose bib, I never did anything with this. So in this matter, we held our end of the bargain. We did a job. We asked to come back and finish the insulation on the pipe, which wasn't in our original agreement.
And finish our inspection.
And finish our inspection, but she ended up canceling our permit, not allowing us back at the property, and not answering our calls, telling us to stop calling. And that's in our submittal packet as well. So we were up against a brick wall here. We wanted to do right by her, and we wanted to get this done the right way like we always do. We butted heads, but it was just difference of personality, I must say. But we did try every length to do right by her. We already gave a job at 50% discount. A 2-bathroom repipe in this market is $12,000. That's what it is. Every company across the board. We gave a discount for her. She said that she needed, her father didn't have much money. We were slow at the time, so I gave her the deal. And it was fine. We went in there and replaced everything. But this wasn't a matter of the repipe. This is the sewer. And everything coming about is trying to find wrong. She was threatening to sue us before we even started.
Right.
You know, and so it's just been a butting heads across the board. So I sent her a text after the fact. And I just want to add this. I sent that text because as a person, I don't like the energy of being angry and so forth. We lost a $130,000 contract in that subdivision because of this job, because of what you talked. The lady, Barbara Stahl, who I didn't do a job for, we didn't work for her at all. We just gave her an estimate. And we had a contract to replace all the water lines in all the park, signed and delivered.
By Tumwater Estates.
By Tumwater Estates. And then we're getting ready to start the very next day. And they said, bring the print back. We're not doing it now. Come to find out it's because of this. And it hurt our business. We had 2 months of work scheduled. Done. Yeah. We lost all that revenue.
Well, let me kind of stop you there. We're kind of veering off into other areas here. I want to go back to this, the scope of the work, because what I'm looking at here that you submitted, it looks like it's entitled A1, and that exhibit says the service date was January 22nd of 2025, and then the services that are described here are a water supply repipe, remove existing water supply system and install PEX, water supply to each fixture, hot and cold. That includes 2 bathrooms, 1 kitchen, and 1 hose bib. Is that what you're telling me is the agreed scope of the work?
Yes, absolutely.
And she paid for that.
Yes.
That was what the $6,000 showing over on the other column represents.
Right. Which what we did is, you said that laundry room we didn't know existed till after. We did come back and pipe that for free. That wasn't on our contract either.
And that's on the exhibit I gave too with the washing machine.
With the washing machine pipe running water through it.
Okay, I need to look at that again. Just bear with me here a second.
It is exhibit.
Oh, it's right there. Gotta be in there.
Yeah, I know it's in your packet. I saw it before, and some of these exhibits just take a second to load. That's why oh, here we go. I see it now. Yep, I've got it.
Which page?
So it looks like it's called E3, and it is on page 23 of the defendant's packet. And it looks like a picture of water flowing into the tub of a washing machine. Okay.
Yeah, that quit.
All right, gotcha.
I actually took a video of it, but I didn't know how to upload that.
Okay.
At the time,
Right.
I took a video.
No, I kind of stepped in there with the question and interrupted your flow a little bit. Is there anything else you want to continue with there?
No, sorry for getting off topic a bit there at the end, but bottom line is we gave a contract, we upheld that contract. And when there was problems, we immediately contacted her to resolve all issues and to do a right job by her father. And we were told that we cannot come back to the job. Our permit was canceled and another plumber was hired. And then this came about. It was.
Wait, what I do want to say is that her original pipes were not insulated.
Oh, I had a video hang up again here. I just want to bring them back to where the
Sorry, it cut out.
Oh, there we go.
But
what I heard was you said her original pipes were not insulated and then nothing after that.
Oh, the original pipes weren't insulated, but when we pulled the permit, and then if you want to look on there, the inspector required us to go back and insulate the pipes. We were just coming back to insulate the pipes without charge to her, considering it wasn't on her original, and we were just going to come back. She wouldn't allow us back on the property. So that's exhibit B2 and B3.
Yes.
From the inspection report.
Okay. B2, B3, I just passed it. Okay. Yeah, I see it. I see it. Yeah, that was submitted by the plaintiff as well. Okay. All right. Was there anything else that you needed to tell me?
No, yeah.
I don't think so.
All right. Thank you. All right. Well, I think I told everybody in the beginning that, you know, if you're going to claim that your claim is based on a contract, one of the very first things that needs to be proved is what are the terms of the contract? What is the agreement between the parties? And differences in opinions, recollections, and so forth. If they're not memorialized in writing and in advance, then it's difficult to reconstruct that afterwards. And even the terms of an oral contract need to be specific and specified. And, you know, you two right off the bat clearly don't agree on what the contract was for, what the terms of the contract were. So it makes it tough to know exactly what the bargain entailed for each party. And it's also less than clear as to what the standard of performance is. In other words, how do we know if the agreement's been complied with or not complied with? There's a standard there. And someone has to bring forward evidence regarding the standard of work that has to be met in order for the term of the contract to be considered fulfilled properly, or in the alternative, whether that term was breached. So, you know, it's a challenge to say the least when there's no written contract between the parties. So I have to fall back on the basic standards of the law, which is that the burden of proof is on the plaintiff to prove their claim by preponderance of the evidence, which means the greater weight of the evidence. In this case, Ms. Giles, you're the plaintiff. You've got the burden of proving that claim by preponderance of the evidence or the greater weight of the evidence. And based on the testimony that's been provided here and the exhibits that have been submitted regarding what the agreement was, the scope of the work, any level of performance or standard of performance that needed to be met, and whether it was or whether it was not, I cannot find by preponderance of the evidence that that burden has been met. Therefore, I'm entering judgment. It's going to be in favor of defense, All American Services. All right, and I'm writing out a judgment to that effect, filing it with the clerk.
Your Honor, did I hear you say that it was going to All American Services?
Entering judgment in favor of defense. In other words, the claim's not proved. So the clerk will give you a copy of the judgment since you're here. And for All American Services, you can obtain a copy of the judgment anytime from the court clerk's office.
Thank you, Your Honor.
Thank you.
And ma'am, the Clerk will have your copy of the judgment right here.
That's. Oh, Our next case with.
Are we finished, Your Honor?
Yes.
That's, yes, that's the end of the case.
Okay, thank you.
Yeah. Case with you and collision and some towing. It sounds like they did not reach a DRC agreement, so it sounds like they're going to proceed to trial.
Okay. We don't have the other party back yet.
Out of the breakout room.
Okay. All right, we'll wait for him. I know we have Summit Towing here, and you're Thurston County Collision.
No, we're both Summit Towing.
Both Summit Towing. Where's Thurston County? Oh, online.
Online.
Okay, gotcha. All right.
Your Honor.
I recognize Brooklyn because she's here for the other type of hearings. Yes, ma'am.
After, I don't know how long this is gonna last, I need to get home, but I would really, I didn't have a nice and neat, thing, because when they first came, they didn't even have any paperwork. So we came back, and when this guy is digging down and puts the pipe, the flex pipe that, whoever
Ma'am,
put in there.
I'm so this is not proper. Okay, I've heard your case, rendered a decision. That's final judgment of the court. And I can't have separate contact with you about your case apart from the defendant's present. That's not allowed. So I can't engage with you about your case right now. But there is no more. If you don't believe the judgment of the court was proper, you may have the right to appeal the judgment to a higher court. But that's all I can tell.
Thank you for your time. Thanks for all the calls, Chief.
Wow. Wow. Ladies and gentlemen, I just don't know what to say. Everybody gets sued. Oh my Lord. I don't know how to work my stuff anymore. It's all messed up. One of those days. It's been one of those weeks for lots of people this week. And we have rounded it out with another great show here in the gallery. But we haven't finished off the whole weekend. We have one more day left. We have Saturday weekend review tomorrow morning at 11 a.m. Come on by, hang out tomorrow. We'll be doing this again all week next week. Same Wolf time, same Wolf channel. Thank you for coming by and hanging out, watching some Hasselink with us tonight, watching some Wohl. I just don't know what to say about some of these cases. I just really don't. Man. Some people just, hey, while I try and get my thoughts together, let's roll some Fred, shall we? Ladies and gentlemen, thank you so very much for hanging out with me tonight. I want to say a special thank you out there to Wendy, Greek, Charlene, Tut, Dan, the Coin Man, and Marty. Oh, thank you so much, ladies and gentlemen, for hanging out and watching these amazing cases with me tonight. It's been a great night. Is there anything, I've been watching this Bricks and Minifigs thing as it's been going around. I wanted to make something, but what can you do? There's just so much content out there. I don't think it's for this. We're more about the everyday, live, cautionary tales directly from court, average everyday man story right here. That's what I put together here at the Lone Wolf Court Gallery. Stuff that we can all kind of identify with in some regard or another. Hope we never have to identify with in most regards, I believe. But anyway, ladies and gentlemen, for me, and the puppies on the ground, I want to say a heartfelt thank you so very much for hanging out with me. Come by tomorrow. We'll be doing the same thing for another 2-hour block. Lanny, you're right. If I mention bricks and mini I may get muzzled. Thank you, Bat Boy is back. Thank you, everybody. I am your Lone Wolf Mooseville. I am your humble host for these little here get-togethers. I'm tired. And I am. Oh, Hammond's rock, right, Dad? That's what I think too. I love it so much. No outro. I got nothing for you. Go. Yeah. Go watch Ferris Bueller's Day Off.